didn't say that the RICO enterprise had to have an illegal purpose.
No, Your Honor, I'm not challenging the jury instruction, nor could the jury instruction be challenged. The jury instruction is entirely consistent with United States versus Boyle. In fact, it's almost word for word the same jury instruction. And in Boyle, as this court may recall, where the enterprise or the instruction was challenged, even though it wasn't set out with specificity what the structure of the enterprise should be, the Boyle court said that's fine. It doesn't have to be. The jury doesn't have to be instructed with that level of specificity. In this case,
but you're arguing, it seems to me, that absent an illegal purpose, there can be no RICO enterprise.
Yes, because it would make nonsense of the statute.
Okay, but is it so? I guess A, what's the authority for that, and B, isn't that really a challenge to the jury instruction?
I don't believe it is. I think that.
Well, did the district court tell the jury that they had to find an illegal purpose so there could be no enterprise?
No, but the indictment did, and the indictment was incorporated.
No, the indictment listed a series of purposes.
Yeah, series of purposes pled in the conjunctive, and the jury instruction, which had the indictment incorporated into it, pled that there were 4 different purposes, 2 of which were legal essentially, and 2 which were illegal.
All right, but I guess I'm asking a basic question to start, which is that if the government had just listed the legal purposes, your view is that that would not be sufficient for a RICO indictment?
No, in fact, district courts routinely dismiss complaints that do not demonstrate that the purpose of the common or the enterprise is illegal in nature. In fact, neither party's been able to find a single case where the purpose of the enterprise was entirely
You're arguing
legal.
that there was insufficient evidence here to prove an illegal purpose?
Correct, or illicit or fraudulent or some type of
Wasn't there substantial evidence?
No, Your Honor, I respectfully disagree. There was substantial evidence of.
Please finish.
Yes, there was substantial evidence, perhaps, of defendants' wrongdoing in the context or using, quote unquote, the machinery of his organization, his entourage, those types of individuals. But there was very little evidence, almost and certainly not sufficient to meet the government's burden of proof, that any of those individuals acted with this common purpose to, quote, recruit women for Mr. Kelly for illegal sexual activity or for the production of child pornography.
So I'd like to just make sure I understand. It sounds to me as though you're making a legal argument that a RICO enterprise has to have an illegal purpose, as well as that here an illegal purpose was charged, but there was insufficient evidence of it.
Yes, Your Honor,
right?
That's correct. That is precisely right.
And I want to understand, in light of Turquette,
Sure.
Why we have to find an illegal purpose as
Yes.
well. I mean, there's language in Satinwood, and most of the cases that have been cited and discussed are in the context of a fraudulent purpose that may have some legitimate enterprise around it, but there's room for confusion there. But Turquette seems to say quite directly that the term enterprise as used in RICO encompasses both legitimate and illegitimate enterprises. So maybe you could help me.
Yes, the issue isn't whether it was a legitimate organization, a legal entity versus a non-legal entity. Turquette held, and the question before Turquette was the exact opposite, whether a RICO enterprise could be exclusively criminal, not whether it could be exclusively legal. And our position is that this was an organization that the government failed to prove had any criminal purpose. The government takes the position that for a RICO enterprise to exist, it need not be rooted in criminality at all, which would fly in the face of Turquette, frankly. Turquette looked at Congress's intent, both the statement of—
Didn't the government prove that one of the purposes of this enterprise was to recruit girls so that Kelly could have illegal sexual activity with them?
They pled it, they did not prove it. What they did prove is that through the course of a period of time, there were perhaps efforts to pass along information, a phone number, to invite someone backstage. There was no evidence presented that any of those individuals did so believing or knowing that someone was underage, that You go to a big concert, there are 17, 18, 19-year-olds. Even the victims themselves said, well, nobody asked me for my age. When the age came about, perhaps Mr. Kelly may have known, and that's what I think some of the women testified to, but there was no evidence that anyone went out there saying, may I find out what your age is? Are you underage? Come back. We want to serve you up to Mr. Kelly. That just didn't happen. And in fact, there is extraordinary evidence that and members of the enterprise, again, these are some of the people, I guess, that testified, repeatedly made it clear that what happened behind closed doors was not something they understood. Yes, there were rules and things they did, these anodyne tasks that were perhaps a little unusual, but not that put them on notice that what was happening behind closed doors was illegal. And we are talking about matters that happen behind closed doors. The fact that a video recorder existed in a bedroom does not ipso facto make it evidence that there is child pornography
You're saying
being
these
produced.
other individuals didn't know that these girls were underage?
That's exactly what I'm saying. I think the evidence that was presented to the jury was deficient in that regard. There was so much excessive evidence, frankly, about Mr. Kelly's wrongdoing that it would be easy to be tempted to go down the path. Well, everybody must have known, but that is just not what was demonstrated at trial. And
Well, the appearance of these girls would be evidence enough, wouldn't it?
These were not 12-year-olds. These were not 13-year-olds. There were some example. What was testified to is that some of them looked young. And having multiple teenagers myself, looking young does not mean you know someone is a minor. And the question becomes, did they have an obligation to ask? Did they have to do due diligence, do inquiry when he said, just go pick somebody up? Again, just using individuals, unwitting individuals who perhaps even turned a blind eye or who didn't inquire further, does not a RICO enterprise exist. And I would leave with this point that simply speaking, I mean, I won't leave with it, but the law presumes in Turquette, which was an entirely criminal enterprise. They weren't speaking to the question of whether it could be a legal enterprise with a one man doing illegal acts in the context of the enterprise and using his employees. So Turquette does not, from where we stand, put this issue to rest. And what the government wants to do is simply read out of the statute organized crime. And at the end of the day,
They want to read out organized crime? What are you saying?
yes, because the purpose of the statute, the RICO statute, is to address organized crime. Now,
It's not in the text, though, right? When you say read it out,
the
right?
definition of organized crime is not in the text of the statute. And in fact, courts have universally read organized crime very liberally, very broadly, and we're not quarreling with that. But you can't just have an organization that is not associated with any crime. Simply speaking, a RICO enterprise is a criminal organization. You can define it broadly, but it's not an organization simply with a criminal. And that is what the government is asking the court to find here. I believe my time has expired.
But I mean, you're not challenging the jury instruction. So you're agreeing that everything the district court told the jury they needed to find was correct, right?
Your Honor, the jury instructions were consistent with every jury instruction ever given in a RICO case historically. And frankly, is consistent with what the United States Supreme Court held in Boyle.
Right.
I don't know how.
So the jury wasn't asked to read out portions of the statute. The
Again, I go
jury was
back-
correctly instructed. And so I guess I'm trying to figure out, you're saying that the evidence didn't support the elements that were correctly instructed to the jury.
What I am saying, Your Honor, is that the government had an obligation, and in fact, the jury was instructed that the government had to prove the theory of the enterprise. The theory of the enterprise included criminal conduct that was pled in the conjunctive. And if it had been just simply legal activity pled in that indictment, it would have been dismissed. Because routinely, again, and we've cited numerous cases, as does the government, district courts simply do not allow RICO prosecutions or RICO suits to move forward where you don't have an actual fraud or illegal or illicit activity that is the moving force or that is the common purpose. This would be outside the realm of, again, contrary to the purpose.
Back on the issue of whether the staff knew the age, sometimes the staff booked the travel arrangements for them, and therefore they had to have identification documents. Isn't that evidence that they knew they were underage?
I think if you look closely at the record, you will see that the government was very clever, frankly, of conflating these issues where I do not believe there was any evidence that a employee booked travel for someone who was in fact under the age of consent. So you have to remember in Illinois, the age of consent is 17. It only becomes a federal crime if it's being videotaped. Now, do these people know what's happening in the bedroom? No, there is no evidence that
Wasn't there evidence that the staff made sure that in his backpack, he had his iPad and recording equipment? The evidence doesn't show that?
It shows that people picked up his luggage. I mean, people pick up my luggage. I pick up other people's luggage. Am I responsible for what's in that luggage? It just takes this to the point of absurdity. We can't say an enterprise exists because unwitting employees are engaging in normal tasks that they do, particularly for high-profile people.
Thank you.
Thank you.
Ms. Bensing?
May it please the court, Assistant United States Attorney Kayla Bensing on behalf of the government. Good morning, Your Honors. I want to start with the defendant's challenge to his RICO conviction and what constitutes an enterprise. As the district court stated at the sentencing in this case, the defendant had a system in place that lured young people into his orbit and then he took over their lives. And so I want to start with this claim that was made in the reply brief and is made today before the court, that the enterprise members or that the defendant used his inner circle to simply carry out anodyne activities. Demetrius Smith, the defendant's—
What evidence is there in the record that the staff who arranged these things knew that they were underage?
Yes, Your Honor. So in September of 1994, I'll start there with the victim, Addie, who testified. She testified that she was 17. She was invited by Kelly's bouncers to come backstage at a concert in Miami. That was 3 days after Kelly's marriage to Aaliyah, in which he bribed a county official in order to hide or alleviate the consequences of illegal sexual activity. And obviously members of his enterprise arranged for that bribery, and so we're well aware of that illegal sexual activity. A few years later, in 1998, Stephanie, who was the victim named in Racketeering Act 2, was approached at a McDonald's by a member of Kelly's entourage. He asked how old she was. She told him that she was 16. Kelly's associate then gave her Kelly's phone number and said Kelly wanted her to call him. This is the same girl who at 17 was instructed by Kelly to give him oral sex in the backseat of a car and to be vocal and make noise while doing so that Kelly's driver and another individual who were present in the car could hear, which was a obviously deeply humiliating experience for her. Turning next to Nicholas Williams, he was one of the defendant's runners beginning in 2003. He answered phones and escorted Kelly's girlfriends inside of Kelly's studios, and he testified that Kelly's female guests were very young, keeping in mind that he was 19 at the time. He also testified that he could hear sexual activity and yelling between the defendant and his female guests. The jury is entitled to infer from that Kelly's employees helped maintain and facilitate Kelly's contact, including sexual contact, with these underage women. I want to also turn to Anthony Navarro's testimony. He was another one of the runners employed by Kelly. Navarro, who started working for Kelly in 2007, specifically identified that he would help answer phones for Kelly's girlfriends. That was his word, and there was some claim in the reply brief that these were just female guests, but he testified using the word girlfriends. And he identified them as looking very young, specifically mid-aged teenagers. And the jury heard testimony from Deronda about how she recognized Navarro as one of Kelly's runners who she interacted with when she was 16 years old being sexually abused by Kelly. In addition, there's Cheryl Mack. She was Kelly's assistant beginning in approximately 2013. She repeatedly saw Kelly with 17-year-old Jane. She had booked travel for Jane as early as April 2015, so she knew Jane's age. And a couple months later, in July of 2015, she testified that she observed Jane going to perform oral sex on Kelly. There's also Suzette Mayweather's testimony. She learned that Jane was 17 years old in the fall of 2015. She knew that Jane was one of Kelly's girlfriends. She observed her following all of the same rules as Kelly's other girlfriends. There's also testimony from Jane about Juice, who was another one of the defendant's girlfriends, but whom Jane testified acted as one of the defendant's assistants. Juice helped teach Jane rules, and Juice also knew Jane's age. I believe that's in the special, I believe that's SA 527. So this is all evidence that the jury was entitled to infer that Kelly's inner circle knew what was going on, that he was recruiting and maintaining underage women for sexual activity.
Does the, I guess the allegation that Kelly was also inducing these folks to come in violation of state law because he was infected, is there evidence that his entourage or the folks in the enterprise knew about Kelly's status as infected with herpes?
Yes, there is. There's testimony that his assistants picked up his Walgreens records. Anthony Navarro, who was one of the runners, testified that he would pick up Valtrex for Kelly. That's at A467 to 68. Diana Copeland accompanied Anna, who was one of the testifying victims at the trial, to the hospital for her STD test. And only Diana Copeland received the results of that test, not Anna. Juice, again, who Jane testified was like an assistant to Kelly, took
Was
Jane.
there evidence that the staff knew that Kelly wasn't disclosing his condition?
Well, a number of the women, in fact, obtained, got an STD. They were not just exposed to it, but they in fact got an STD.
But that doesn't go to the consent question. I mean, if they consented, then it wouldn't be a violation of state law, right? If the girls had consented knowing that he had herpes, that would not violate state law?
Well, the state
right
law,
about that?
I believe the state law, the violation is specifically exposing somebody to an STD. The jury was instructed that R. Kelly did not also give consent in those, that they did not give consent in those circumstances. So that was part of the jury
Right,
instructions.
but my question is, was there evidence that the staff knew that there was lack of consent?
Well, I don't think that there was direct testimony on that, but I do think that a jury, drawing all inferences in the government's favor, was entitled to infer that from the evidence that did exist. And again, just to complete the record on that, about the testimony by Jane about Juice, that Juice took Jane to see a doctor in downtown Chicago, and she was prescribed medication for her herpes infection. I also, though, want to talk about another illegal sexual activity for which there is tons of enterprise evidence that that Kelly has not really raised on appeal at all, and that is forced labor. That the defendant obtained labor and services here, sex acts, through threats of serious harm or physical restraint against the victims. And the evidence is replete with examples of how tightly tied the forced labor charges and the predicate acts were to the enterprise.
So I'm a little concerned about applying the forced labor statute in this context, because it seems that you run the risk of really sexualizing or federalizing all kinds of state sexual assault and being able to turn it into federal offenses with much different consequences for the individuals. Can you address that concern?
Yes, of course. And I would just return the court to the plain language of 18 U.S.C. section 1589A, which prohibits whoever knowingly provides or obtains the labor or services of a person by any number of combination of the then subsections of that, which includes a scheme, plan, or pattern intended to cause the person to believe that if the person did not perform that labor or services, the person or person would suffer serious harm or physical restraint.
So wouldn't that apply to any kind of rape prosecution?
So I don't think the court has to reach the outer boundaries of what the statute may or may not apply to in this case, because there was a clear pattern that was far beyond something like a one-time rape. So for the specific victims, there
But
were
in some
three.
cases, we are talking about just one or two instances, right?
Well, I don't think so. So as to Geronda, what was charged was a specific instance as to the forced labor. But of course, there was an entirety of the pattern that led up to that specific incident where he choked her, he spit on her, and then he made her perform oral sex on him. What led up to that was a whole series of Kelly enforcing his rules, teaching her the rules, enforcing the rules, and then punishing her.
So you think we should focus on the actions that constituted the force as opposed to the labor that was forced?
Well, I think as to labor and service under this court's definitions of those recently in Ranieri and recently in Marcus, sexual activity, I think, clearly falls within the definition of the expenditure of physical or mental effort, especially when fatiguing, difficult, or compulsory, the performance of work commanded or paid for by another. And of course, in the context of prostitution, I think that the court would have no issue finding that that constitutes forced labor. And here, this is no different. A sex act is a sex
But
act.
what about a single one? What about a single rape?
Well, again, I don't think that the court has to reach the question of the sort of the outer boundaries of that question about a single rape. I guess what I would say is here, the conduct has met the elements of forced labor, and I think even the district court noted in its opinion that this was the kind of case where the defendant had a pattern in place of making these women feel isolated and ashamed, and he used the enterprise to make them feel like they were confined and that they had no way out. There was an expert who testified at trial as well about the defendant's use of these isolation.
Right, but the issue is the labor component,
Yeah.
it seems to me. So what does the isolation have to do with labor? It might all be true, but where is their labor?
Well, I am just pointing the court to the other portion of Section 1589, addressing the court's question as to whether a single rape could constitute forced labor. I think here, sexual activity can constitute labor or services.
Right, we know that. Ranieri says that. What about the facts here? This is very different than Ranieri, right?
Well, I think in many ways it is similar. For example, the women were forced to give over collateral. Geronda, who was one of the victims of the forced labor charge, testified about how she had to write false letters. Faith also was forced to send a text
But is
message.
that the labor? So writing false letters is the labor?
No, the labor
I mean,
would
Ranieri,
be...
these folks were doing other things. They were doing things for free, right? That would be easily described as labor. Some of it sexual, some of it not.
Well, again, I think that people pay money for work on websites, people pay money for transcribing tapes and reviewing articles, and people pay money for sex. So I think under the definition that this court has given in Ranieri...
So I think that's where we're back again. You keep saying we don't need to go to the outer boundary, but it seems to me your argument is any sex act, including a rape, is forced labor.
I believe that sexual activity does count under this court's definition of labor and service. And again, I would just note that, of course, the other provisions of the forced labor statute would also have to be met. And that may be where there's a limiting principle in terms of whether a single rape would constitute forced labor, because the whole other part of the statute would have to be met, which includes, you know, as relevant to this case, the use of the means of any scheme, plan, or pattern intended to cause the person to believe that if they didn't perform the labor and services, that person or another person would suffer serious harm or physical restraint. And so that brings me back, I think, to sort of my initial point, which is, and I see that I'm over my time, so I can continue to address sort of the record evidence.
Please go ahead. There are a lot of issues here, so we may want to get to some others too.
Okay, so just very briefly, I think the record is replete with evidence that the enterprise was tightly tied to the facilitation of the forced labor predicate acts in this case. Members of the inner circle heard Kelly beating his girlfriends. They knew that Kelly was isolating his victims, and they helped him do it, including by enforcing his punishments, such as watching over them while they were confined to a bus for prolonged periods of time. There's testimony about that from the Mayweather sisters, from Diana Copeland, and employees were punished when they didn't comply. There were financial sanctions when they, for example, Copeland testified that she let Anna escape. And so I have numerous other examples of that, but if the court has questions about any of the other charges.
I'd like to ask about restitution.
Yes.
And about, it seemed to me that the record was weak, that Kelly infected Jane, and the second young woman with herpes in states where the exposure was illegal. And I wondered if the government, what the government's position is on that. If Kelly gave Jane herpes in the state where the exposure was legal, someplace other than New York or California, do you agree that she would not be entitled to restitution?
Well, I think the record here establishes that the first time that Jane had sex with Kelly, so her first exposure to the STD was when she was in California, and that was the basis for that particular racketeering act, and for the charge as well. And so that was the first time that she was exposed. She subsequently, later that summer, tested positive for having herpes. And so I think that the record has demonstrated that the crime was exposing her to herpes, and there's direct causation that she then later contracted herpes. And just to close the gap, she also testified that she had not been with any other sexual partners at that time. So I think here we do have direct and proximate causation, and of course, the district court had the facts to make that determination. And as to Stephanie, so she had filed, I believe she'd filed a letter with the district court indicating that the defendant had exposed her with herpes, and that was part of the sentencing record. But in addition, the government had referenced a report of investigation, an interview that she had given to HSI agents, that during the time that she was with Kelly, he never wore a condom.
Yeah, let me go back. I'm sorry, I'm just looking at my notes.
Yes.
But wasn't by the time that Kelly met Jane, wasn't he on Valtrex by then?
So the testimony was that, first of all, herpes can be transmitted even while you are taking Valtrex. That was part of the expert's testimony in this case. And there was also testimony that his use of Valtrex was very inconsistent. So there's testimony from his doctor that the doctor would prescribe 11 months of Valtrex, and then 4 months later, he'd have to be prescribing more Valtrex. So I think there's testimony from which the district court could conclude that he was not taking Valtrex as it was prescribed, which simply increases even more the risk that he could transmit herpes to
And this
Jane.
is applying a preponderance standard. in any
Exactly,
event,
of
is that
course,
right?
Your Honor.
Okay. So if you could address Stephanie now.
Yes, thank you so much. So, so in this report of investigation from HSI, which the government referenced in its letter seeking restitution for Stephanie, we represented that the only person that she was with was Kelly at that time, and that was in 1999. Of course, in 2000, Kelly did have a negative culture for herpes, but there was testimony from both his doctor and the expert witness in this case that it is actually quite frequent that you might get a negative culture even when you have herpes, because the timing of that test.
And
is
there was
so-
evidence that she was having sexual relations with no one else?
Correct.
Is
That
that
was part of the report of investigation that the district
Okay.
court had before it. There was a specific 3500 piece that was referenced.
Okay, thank you.
Can I ask you, I guess, to come back to what I think is a legal point? Do you agree with Ms. Bonjean that there has to be an illegal purpose in order to establish an enterprise, which is really the first element of the RICO claim?
No, I think as we have made very clear in our brief, that is nowhere in the text of the statute, that is nowhere in the Supreme Court's precedent, and in fact, there is precedent in this circuit that does not require any sort of illegal common purpose, and specifically the court's opinion in Daddario, but also a recent summary order in this circuit in the Ranieri case. In that case, there was a completely legal common purpose that was alleged, and this court found that was completely sufficient.
Right, and then I guess the next question is that I think Ms. Bonjean's argument is that when you've decided to charge an enterprise with a list or a series of purposes, her view is you have to prove them all beyond a reasonable doubt, or you haven't proved the enterprise in question.
Well, the jury instructions, in fact, stated that the government is not required to prove each and every allegation about the enterprise or the manner in which the enterprise operated. the enterprise must be essentially the one that was alleged in the indictment. And for all of the reasons I started with today, the enterprise was the one that was alleged.
Well, I guess that's the question. Is it essentially the one charged in the indictment if the jury only finds 3 of the 4 purposes proven beyond a reasonable doubt?
Yes, I absolutely think that it is. It's not like there's some sort of unfair surprise that R. Kelly's enterprise was the Gambino crime family. I think if the court looks at the definition of the enterprise in the indictment, the means and the methods used by the enterprise, those were proved by the government at trial. And so I think that there is sort of no way on this record, and I can continue to go through the various factual allegations if the court was like, but I would also reference the court to the district court's very thorough opinion in this case as a place to look for the evidence of the enterprise, which was one I think that was alleged in the indictment. So I think under the factual record, there can be no doubt that the government proved that the enterprise was essentially the one alleged in the indictment.
All right, and nobody asked for a special verdict form that would have the jury identify which purposes were proven beyond a reasonable doubt.
Nor that's of course true, and I think that this argument has been thoroughly waived, including by the statements today that the jury instructions were appropriate under both parties' position. But also I think we're talking about the existence of an enterprise, and a common purpose is sort of one sub-element of what constitutes an association in fact enterprise. So I don't think that there need to be any sort of special verdict as to which common purpose was proved.
But you mean if they all thought that what they were doing was just promoting his brand and music, that the illegal purposes would be irrelevant to the enterprise?
Well, so again, in Raniere, there was a very similar common purpose that was alleged. It was to promote Raniere and to recruit new members into the pyramid organizations. That was the common purpose that was alleged, and this court found that that was sufficient. Now here, the government alleged additional common purposes, and the government continues to submit that the proof at trial was overwhelming, and certainly that the jury's verdict should be credited.
The criminality is picked up by the pattern of conduct.
Correct, and also the required nexus between the person acting through the enterprise to commit a pattern of racketeering activity.
All right, thank you very much.
Thank you very much.
Ms. Benson, we'll hear now from Ms. Bonjean for 3 minutes of rebuttal.
Thank you, Your Honor. I'll start really briefly with the forced labor issue. Forced labor counts were based on a single act in both cases, Jahanda, an act of oral sex, and in Faith, an act of oral sex. I know the government, again, keeps referring to all of the enterprise activity the activity that they allege is enterprise activity. But at the end of the day, those forced labor counts were premised on a single act. Unless the court is prepared to say that a single act of oral sex, even if it's forced, frankly, constitutes forced labor, that is just making federal law coextensive with state law. And that is one of the problems with that argument, which we did raise in our opening brief. The government is taking the position that a RICO enterprise need not be rooted in criminality. That is what they are saying. And that is a new position that frankly is unique and not really supported, including by D'Addario, where D'Addario,
Well, in D'Addario, there was an estate that had to be administered, and there was nothing inherently illegal about that, right?
no, but the court in D'Addario did say in the context of after finding the estate to be an appropriate structure, the exact language was D'Addario found that the individual defendants were alleged to assist the executor of the estate to effectuate his schemes. It was a estate that effectuated schemes, an estate that engaged in criminal activity. It was an estate that engaged in illicit activity. And so what the government is saying is, in this case, if we merely charged the defendant with an enterprise that's common purpose was simply to promote his music, that would have been A-okay. But I think that is...
But why is that wrong if the government also has to prove a pattern of criminal activity, racketeering activity, and a nexus?
Well, I think in Boyle, the United States...
In other words, the RICO's looking at organizations that are then used to commit criminal acts. And it doesn't have to be a criminal organization. It could be a completely legitimate organization, but if it engages in racketeering activity, then it violates RICO.
Yes, but first of all, if you look at the racketeering acts, it's Defendant Kelly's acts. Those are the acts that are charged. There are no acts except perhaps, I guess we could make an argument about Demetrius Smith's conduct after after he learned that there was illegal activity occurring with Aaliyah allegedly. He's a little much of an outsider, but overwhelmingly, and I think all of the racketeering acts involved the victims and defendant, not the enterprise, the alleged enterprise.
But I think you're conflating the fifth and the first elements of a RICO claim. The first is just the existence of an enterprise. It can be a labor union, right?
Again, Your Honor, I'm not talking about the ascertainable structure. I'm talking about the
No, I'm not
structure
talking about the
still has.
ascertainable structure either. I'm talking about the legal entity of a labor union is sufficient for
Agreed.
enterprise.
Agreed, it still has to have a
fifth
purpose.
element, the fifth element is that the defendant conducted or participated in the conduct of the enterprise through his previously established pattern of racketeering activity. So it has to be a link between what the defendant is doing as a pattern of racketeering activity and the conduct of the enterprise. That's the last element. You seem to be flipping that into the enterprise, and I think that's where you're getting confused.
I don't believe I am. I think the United States Supreme Court in Boyle made it very clear that an enterprise has to be more than just the pattern of racketeering. It has to be.
Yes, it has to. Yes, an enterprise has to be demonstrated. An enterprise is defined as an entity, legal or not legal, that has purpose, structure, and form,
Right, and
and
one
history,
of, I'm sorry.
and history.
Yes, and one of the elements of the structure for an association, in fact, enterprise is a common purpose.
Right, but not
Right.
an illegal common purpose.
Well, I mean, then we are, again, this is a new approach that would,
I don't think so. I mean,
I-
again, you didn't object to the jury instructions.
I
so don't
didn't
see how-
try, I didn't represent Mr. Kelly at trial.
No, I
will
mean,
point out.
Not
but-
you personally, right?
But let me put, I think that that would have been a frivolous objection when every single, including the United States Supreme Court, has said these exact instructions are proper. What has never come up, and because the government has extended the RICO statute to a set of circumstances that's so beyond what the framers intended, which was to get at organized crime. And now we're talking about an organization with an alleged criminal, but not organized crime. And it is not enough simply that there be a pattern of racketeering that satisfies the enterprise. There has to be something more. The pattern of racketeering can be proof of the enterprise, but it cannot simply be the only evidence of the enterprise. And I think if the court looks at the evidence closely, the government conflates a lot of the evidence that came in, but at the end of the day, we are talking about, in a couple instances, some of these victims that testified were very clear that no one asked me my age. And if you're 17 years old in the state of Illinois, would not necessarily put anyone on notice that what's going to happen is illegal. It's preposterous to suggest that because a runner goes and picks up a famous person's medicine, that puts them on notice that Mr. Kelly is exposing and giving STDs to his partners. And for example, Cheryl Mack, as an example, she testified very clearly that when she saw some inappropriate conduct with Jane, she quit the next day. That is not evidence that she came together to participate in recruiting girls or producing child pornography. That's evidence that, whoa, this is not what I would approve of, and I'm out of here. So this shows that this was not a collection of people who had a purpose to recruit girls for sexual abuse or for child pornography. Whether they turned a blind eye, whether some of them suspected that some of these girls were underage, that's a whole different matter. And once we get into that sort of territory, we're going to say that constitutes a RICO enterprise. Well, we have a lot of organizations, we have a lot of frat houses, we have all types of organizations that are now going to become RICO enterprises. And that has not been the case. Frankly, if that was the case, it's unclear why Bernie Madoff wasn't prosecuted under a RICO theory, because he certainly was using the machinery of his organization to carry out a RICO enterprise, and yet he wasn't. So I think,
Well, he got 150 years. I don't know that it mattered, but I mean, I guess.
agreed, but I think that I think there, if you look really closely at the law, these are all cases where it was assumed absolutely the RICO enterprise was criminal or illicit in nature. It would be contrary to the purpose of the statute. Now, I agree
Well,
that
the standard instruction from SAND, which is, generally what we look to in this circuit, says an enterprise includes any legal entity such as a partnership, corporation, or association. And then it goes on to describe non-legal entities that may also meet the definition. So your view is that that's a wrong instruction?
my view is that that the instruction was proper in accordance with the way that instruction has been given throughout history in this district and the United States Supreme Court in Boyle. What is problematic is that it is clear that the heart of the purpose of this was illegal activity. That's what was charged. None of this evidence really went to promoting his brand or his music. All of the government's evidence allegedly went towards his illegal activity. So it's kind of disingenuous to say now, oh, well, there needs to be no nexus. We can just say that this was an organization that was out there promoting his music. And oh, by the way, there were, we can call it a RICO enterprise so long as Mr. Kelly is doing these criminal activities and relying on his, again, underlings, whether they know it or not, to facilitate it. And that, I think, is not what was contemplated by the framers of this statute.
All right. Well, thank you both.
Thank
We
you.
will reserve decision. That concludes the arguments on our argument calendar. We will also reserve the two that have been put on submission. And with that, I'll ask Ms. Beard to adjourn court.
Court stands adjourned.
Now that we're gathered here today, what up, man? What's going on? Y'all heard that? Y'all seen it? I mean, I seen a lot of people in the chat said, bias. I mean, I had to. The first time, during the Chicago appeal, I kind of felt like that. I felt like that. Like I can hear it, but then this time around, I have to understand it. Having a little bit of understanding of how this thing go. These judges, they asking Jennifer, question. This male judge was more so. He was more so irritating, to me. But they want to specify, they want to understand, what are you intending to do? But, then we go to the state. Yeah, they was allowing her to talk. But then once they started to ask her questions, y'all see how she was all over the place. The first thing I want to point out is that one thing I want to point out that I did catch was the state said the first time that Jane was exposed to herpes was in California.
Right.
They said the first time she was exposed was in California. But you got Jane to testify and said that they had sexual encounter in Florida. So you got a lot of people who's been arguing this point on the YouTube streets as to, They was having sex at the Dolphin Hotel. The police came and knocked on the door. This is what they stopped having sex, right? She went in the bathroom. He opened the door. The police did what they had to do. They left. They went back to doing what they had to do. So how was the first time she was exposed to sex with Mr. Kevin in California if they supposed to been having sex at the Dolphin Hotel?
Magic, bro.
And this was from the government. This ain't even Jennifer saying. This ain't
4968, please. Jeff,
what
4968.
we saying. This is what the government just testified to in this appeal.
Susie Brian, please call 941. Susie.
You know what? I sit up here, man, and I think Jennifer did a really good job of explaining herself.
Yeah.
Male lawyer was damn irritating, but my thing is this: in order to get to an understanding, you got to ask questions. You just can't sit your ass up there and let a person talk, and you don't even ask or act like you have any level of intrigue.
Man, Brandon, to the corridor, please. Man, Brandon, to the corridor.
I agree. Now, when you talk about forced labor, a sexual act, an isolated sexual act is considered forced labor. You know, when these women didn't say, you know, it wasn't a job. You know what I'm saying? If having a sexual encounter with someone is considered as forced labor, man, well, why do women go?
I done put in that work, then.
You hear what I
put
say?
in that work, man. Yeah.
But why do women go to jail for prostituting? They getting paid, so that's not forced labor, right?
Right. You know, it's amazing because Jennifer broke that thing down. They only talked about one time that something happened.
Mm-hmm.
And Faith Roger full of shit because, first of all, she's a prior bad act witness. She don't even count. And then you say, and I think I said this on my live last night, Faith was sitting up here talking about, oh, she was so intimidated because it was a gun on the nightstand or on the table. Now, you know how many times I done did it with a pistol on the nightstand, bruh?
Right.
You know how many people I could go to jail because of that, you know, just the way that you saying it? Oh, he had a gun. He didn't point it at your head. The thing about it is, man, it's just like certain things just had to be in the environment with R. Kelly shit. Well, he was there and there was a person with a camera. So, I mean, it's madness, bro. And I feel like, you know, of course, the oral arguments was short. I think 7 minutes. I think that it could have been more argued. But, you know, they have to do this thing in due time. They already got the transcripts, man. They already got, you know, the text messages. They already got all this stuff.
And to speak on Demetrius Smith and Aaliyah, Demetrius testified that Robert had no knowledge of the bribery. Demetrius testified that Robert wasn't aware of the bribery. They had no proof of this marriage. They had no proof of a sexual relationship between Robert and Aaliyah.
You know, and just the elements of RICO, man, alone, I don't understand. Like, you know, you sit up here and said he was running an illegal illegal enterprise, but then you say it was not illegal, and then you say it was legal, and that's not illegal. I mean, they don't even know what they're doing, what they're talking about.
Like when Jennifer said, well, how did it promote his music? Everything y'all talking about is pointing to the defendant.
Yep. Absolutely, man.
And a motherfucker, now we got another point that we want to point out. Another point. How can I take Derek to a doctor's office and Derek go and have an STD test and the doctor office give me Derek STD results?
HIPAA law violation.
Why the doctor's office wasn't charged? Why these women? Why didn't Jane sue that doctor's office that she went to visit? You wanted restitution from R. Kelly? You clearly can go sue this doctor's office and be sitting on a bag. You can sue this doctor's office and be sitting on a bag. You think the doctor's office finna risk being sued and put out of practice by giving somebody else's medical records? And hungry as the Clary family is, as greedy as the Clary family is, as shiesty as the Clary family is, if it was in fact a situation where they gave Diana Jane Doe number 5 medical records, man, her mom and daddy, man, they would have been all over that shit.
It's been a mess, man. It's been a mess. I just, at this point, I mean, I'm just hoping against hope. You know, I tell people that we got to have our alternatives in order. We got to have our ducks in a row and make sure.
And we lost Derek. But we gotta make it make sense, man. We gotta make it make sense. Somebody else receiving another person's medical record, just because somebody went and picked up some medicine, that makes them aware of what the medicine is used for. You also had the doctor testify in trial that Mr. Kelly never tested positive for having the STD, but he was giving him the Valtrex. We got to make this make sense. You have the government just come out and say the first time that Mr. Kelly exposed Jane Doe number 5 to an STD was in California. But when you listen at what the moms say, this is why Jane Doe number 5 was in California. The mom said why Jane Doe number 5 was in California, you better stop taking shit for granted. That man just spent $20K or better on you. Ain't get no coochie, and then you not at his show. That's disrespectful. A slap in the face, really? You better do some crocodile tears. This is the shit. This is the problem that I think people have questions about. Because if their first sexual encounter was in California, how in the hell did they have sex at the Dolphin Hotel? And if the Dolphin Hotel was the first time that they had a sexual encounter, that means the first time that she would have been exposed to an STD would have been in Florida. You got to make this shit make sense. We have a right to question the shit that we're hearing. We have a right to have questions. Then you talk about Jerronda Pace. Oh my God. Are you serious? Who was represented by Susan Loggins. That says a lot, right? We have Jerronda Pace, who was represented by Susan Logan. who talks about jumping this man's gate, who talks about when she jumped the gate and got caught. She said that someone allowed her to enter Mr. Kelly's home. She also said that Mr. Kelly wasn't there. She came up with this crazy story. She took pictures in the man's bedroom. Why she have no pictures with Mr. Kelly? Why she have no pictures with Mr. Kelly? Could she have been one of these women who was suing Mr. Kelly that Miss Susan wasn't filing paperwork for? Then you have they talk about Demetrius Smith, who also testified that Mr. Kelly had no knowledge. Now, what I want y'all to hear is this, right? Because the government said that none of these people asked questions about the age of these women. Well, when you go to the paperwork, excuse me, y'all. We're going to go to the paperwork. And shout out to a view, Tracy. A view from Tracy Point for this information. Let's get this off right quick. Let's get this down. Let's add here. Because she's going to talk about, in the paperwork, it talks about the people who work for R. Kelly, talks about them IDing these women, taking identifications to prevent these type of things. And shout out to everyone in the chat. You know, shout out to everybody that's in the chat. Most definitely, man. But I want you all to not be discouraged. And they talked about all of the employees. Also, let's get to it.
New York failed in filing this RICO is that they only have one person, and that one person cannot be the enterprise and the individual that they have on trial. And so this is the first video on this part of the appeal, which is, I believe it was broken up into 4 parts, and this is part 2 that we're going to begin today. And I believe that this portion of the appeal is going to be broken down into about 4 different videos. And so I'll be posting those videos today, and expect about Chrysler Corp. and 116F3D225, 226-27, which was the case. And I'm not going to read all of that. You guys know I usually just read the case number and when it was heard. And so Fitzgerald versus Chrysler Corp. was heard in the Seventh Circuit in 1997. Chief Judge Posner cautioned that where a statute is broadly worded in order to prevent loopholes from being drilled in it by ingenious lawyers, there is a danger of it being applied to situations absurdly remote from the concerns of the statute's.
Hold on, you guys. I want to go to the video that she did when it talks about the enablers, the employers, the employees, and enablers. Right here. This is the one we want. So this right here, I'm gonna play this clip, this video right here from Tracy. Shout out to A View from Tracy Point. And this video is gonna tell you about what the employees testified to. All of the employees that was in Mr. Kelly's case, who the government claims that is a part of the RICO, was a part of the RICO organization. So after we play this, we're gonna come back later. But listen at what now y'all heard. They talked about all of these different employers, but listen to what these employees testified to, what they had to do. The government want to make it seem as if they was just out here targeting young women. But let's go.
One, Demetrius Smith. Demetrius Smith, friend and personal assistant for the defendant with 1984 to 1994. Smith met defendant as a teenager when he was still attending high school and singing in subways in the mid-1980s. Smith was first a friend and mentor to the defendant, and then began working as his personal assistant when defendant received his first record deal in 1988 or 1989. Smith worked off and on for defendant as a personal assistant until around 1994. Smith's responsibilities included assisting the defendant in things he needed and with scheduling. Smith testified that defendant met Aaliyah through his manager, Barry Hankerson, who was Aaliyah's uncle. Smith testified that from his perspective, their relationship was strictly about music and that he never saw defendant take Aaliyah out by herself. Smith did concede there were short periods of time when defendant might be alone with Aaliyah. There were times when he thought defendant and Aaliyah were overly playful or too friendly, and he asked defendant if he was messing with Aaliyah, to which defendant always responded no. Smith raised those concerns a few times, but only learned that the relationship was more than platonic in 1994. Number two, Anthony Navarro. Anthony Navarro worked as a sound engineer in defendant's studio for 2.5 years. Navarro understood it was entry-level position and would include such duties as cleaning, doing food runs, and driving guests around. Navarro testified that numerous people came through the studio, including different girlfriends of the defendant. One of his responsibilities was to drive the girlfriends where they needed to go. He was instructed not to speak with defendant's guests. Navarro explained that defendant's guests were generally required to ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unaccompanied. Sometimes these guests would stay at the studio for an extended period of time, but could leave if they wanted to. Navarro did not know the details of why any female guests visited. Oops, click too many times. Let's get back up here. Okay. Navarro never picked up female guests who appeared to be underage. They appeared to be around his age, in their early 20s. Navarro had never seen the
So now this is another thing. Y'all just heard they talk about Navarro. You just heard the government talk about Navarro. He was 19. He said when he would pick these ladies up, they would appear to be younger than him. But then when you go to the testimony, the paperwork, and listen to what the paperwork said, what Navarro said during the trial.
Sometimes these guests would stay at the studio for an extended period of time, but could leave if they wanted to. Navarro.
This is Navarro testimony. These women would stay for an extended period of time, but they could leave if they wanted to.
Ask permission if they wanted things or wanted to order food, and they were not permitted to wander the studio or defendant's home unaccompanied. Sometimes these guests would stay at the studio for an extended period of time, but could leave if they wanted to. Navarro did not know the details of why any female guests visited. Oops. Click too many times. Let's get back up here. Okay. Navarro never picked up female guests who appeared to be underage.
Now, did y'all hear that? Did y'all hear that? It say Navarro never picked up female guests who appeared to be underage. But you just heard the government during the brief say that Navarro said that when he picked the girls up, they appeared to be underage. Now you see how they switched the words around? Navarro said that girls did not appear to be underage, but the government said that he said the women appeared to be underage. Did y'all catch that? Did y'all catch that? How they switched this shit, the government? This is, Miss Tracy is reading the transcripts. Now, how do they say the man say the girls appear to be underage, but then his own words said that girls did not appear to be underage? But let's keep going, man. It's just bullshit, bro.
They appeared to be around his age, in their early 20s. Navarro had never seen defendant engaging in sexual activity in his home or in his studio. Navarro went on tour with the defendant and observed that invites would be distributed to attendees for after parties. Sometimes defendant's phone number would be on the invites. At times, he would see defendant's phone number distributed to people at the mall or at a restaurant. Navarro never saw underage girls backstage. Navarro recalled that identifications were checked before people could go backstage.
Did y'all hear that? What did Navarro say? Identifications were checked. Identifications were checked. So how did Jane get backstage during the concert in Florida? Man, look here, bro. These are just my opinions, man. I'm not asking nobody to believe me. I don't go back and forth about how I feel about things. I don't go back and forth about how I see things. But one thing I do is listen, and I have questions.
His home or in his studio. Navarro went on tour with the defendant and observed that invites would be distributed to attendees for after parties. Sometimes defendant's phone number would be on the invites. At times, he would see defendant's phone number distributed to people at the mall or at a restaurant. Navarro never saw underage girls backstage. Navarro recalled that identifications were checked before people could go backstage, but he could not recall whether people had to be 18 or 21. 3. Tom Arnold, Runner Studio Manager from 1998 to 2011. Oh, let me go back up because I don't think I read. Anthony Navarro was a runner and sound engineer from 2007 to 2009. Okay, so Tom Arnold, runner studio manager from 1998 to 2011. Tom Arnold worked for defendant from 1998 to 2011. He started as a runner and eventually became his studio manager and road manager. One of Arnold's responsibilities working for a defendant was to provide transportation to his guests, which could include men with whom defendant played basketball, a musician, and his female guests. If defendant wanted Arnold to transport a guest somewhere, defendant would tell him directly, or someone with defendant would make the request. Arnold testified that the protocol for driving guests from one location to another was to open the door for them, turn the rearview mirror up, and then turn the radio on to a reasonable volume. Arnold understood that turning the rearview mirror up was to avoid eye contact with defendant's female guests and to ensure their privacy. Guests at the studio were required to sign confidentiality agreements.
So I had to stop because if Mr. Kelly got the driver turning the mirror up to avoid eye contact with the female guest, turning the radio up so that the women could talk in private or whatever. So all of a sudden he get one woman, he say, I want you to give me oral sex and I want you to make noise so that the person driving can hear you. So that the people up front, so the person up front that's driving can hear you. I want you to turn the mirror up. I want you to turn the radio on for privacy, but also I want the female to be loud enough so you can hear her as we have sex while you driving. Man, I tell you, bro. I mean, it's just shit that I have questions, man. It's just they're only questions that I have. That's it.
Agreements that prohibited guests from recording or taking photographs. Staff would either take Polaroid photos of guests or copy their identification to confirm the identity of the person signing the confidentiality.
So I want y'all to listen to that right there. She said that they would take Polaroid photos of guests and copies of their identification. Now, where would Mr. Kelly keep these records? What if those were the records that were in the storage? What if these records was being held in this storage where the government seized all of this property? Now, if they was keeping record, this is from 1990s. From the 1990s, every guest, they would take Polaroid photos of every guest and copies of their identifications to attach to it, also a non-disclosure agreement. So if Mr. Kelly was keeping all of these records, he was keeping all of these records. Now you see why they came in and they wanted to take every goddamn thing. Because they were trying to find out. They were trying to get a hold to these records. Somebody that knew what was going on, they alerted the government that, this man had all of this shit. He had all of these records. Because why wasn't any of this information presented? And I feel as though to hear these workers saying that they would take Polaroid photos of the guests and also their identification along with a non-disclosure agreement, I feel like if these women who accusing him wasn't a part of that, I don't think they ever dealt with this man. I don't think they ever dealt with him. because any woman that dealt with him, they would have had to have identification. They would have had to have a Polaroid photo. Those were practice. That's just how he ran his business. And that's just my opinion.
Turn the rearview mirror up, and then turn the radio on to a reasonable volume. Arnold understood that turning the rearview mirror up was to avoid eye contact with defendant's female guests and to ensure their privacy. Guests at the studio were required to sign confidentiality agreements that prohibited guests from recording or taking photographs. Staff would either take Polaroid photos of guests or copy their identification to confirm the identity of the person signing the confidentiality agreement. Okay, the policy of having studio guests sign confidentiality agreements originated with defendant's business manager and lawyer. Arnold generally had no interactions with defendant's female guests. If a guest in the studio was hungry, they would call the front desk and Arnold would arrange to get them food with petty cash that was at the reception area. If a guest wanted to move from one location to the studio to another, Arnold would get permission to escort the guest. If a guest wanted to speak with the defendant, Arnold would relay the message to the defendant. Arnold explained that generally guests would not be able to roam the defendant's studio and home freely, but would ask for permission to go from one part of the studio to another. Arnold testified that there were instances when he would provide defendant's phone number to a woman, not normally in a concert setting, but an after party or at a club or possibly at the mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identifications were checked to ensure that Arnold did not.
Let me take that back for the people in the back. Let me back up for the people in the back.
A concert setting, but an after party or at a club or possibly at the mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identifications were checked to ensure that Arnold did not testify in a concert setting, but an after party or at a club or possibly at the mall. There were also other members of the entourage who would give women defendant's phone number. Underage people were not permitted backstage, and identifications were checked to ensure that.
So I'm trying to understand this, bro. These are the employees, and these employees are testifying to the fact that identification was checked. No underage people were allowed backstage. That's male or female. And they checked identifications to assure that did not take place. But you just heard the government say that the workers said that the girls looked young. They looked younger than him. He was 19 and they looked younger than him.
Arnold did not testify that he provided defendant's phone number to any woman underage. Arnold testified that he sometimes arranged travel for defendant's female guests until they began using a professional travel company. Arnold would obtain the guest identification to arrange their travel. Arnold did not testify that he ever booked travel for an underage female guest. 4. Suzette and Alicette, Aleసిett, Alicette Mayweather, personal assistant in 2016. Suzette and Alice, child, this spelling just don't even make no sense to me. What did we say this was? Is it Alizette? Suzette and Alizette? I don't know. Worked as personal assistants for the defendant. Suzette worked for the defendant between October 2015 and February 2017. And then I'm going to call her Azette, worked for the defendant between late 2015 to June 2016. Their job responsibilities were to tend to anything he needed: running errands, grocery shopping, taking care of laundry, arranging accommodations for guests, female and male, coming into town, and booking airfare. Suzette and her sister testified that defendant had several live-in girlfriends during this period of time. They testified that defendant was controlling of his girlfriends, expected them to follow certain rules, dress down in baggy clothes, and suspected he slapped or spanked them previously. On a couple of occasions, the sisters expressed concern amongst themselves about defendant's mistreatment of Azriel. The sisters denied that they took any action at any time to assist defendant in procuring girls or women. Number 5, Diana Copeland, personal assistant, executive assistant, intermittently from 2005 to 2018. Copeland began working for the defendant in 2004 or 2005 as a personal assistant and worked off and on for the defendant until 2018. Her responsibilities were largely household in the beginning, tending to housekeepers and nannies and making sure they were paid. Later on, Copeland would do administrative jobs like answering phones, maintaining defendant's schedule, and tending to defendant's guests, which could be anyone from a record label executive to a personal guest. Copeland would make hotel and travel arrangements for the defendant, his entourage, and his girlfriends. Copeland would sometimes carry defendant's backpack, but she never went through it. She did see an iPad in one of the backpacks once. During her last stint of employment with the defendant, one of Copeland's responsibilities was to help him get control of his finances. Defendant had difficulties reading and writing. He had no control over his bank accounts, did not even know his social security number, and did not know where his royalties were going. Defendant instituted rules for guests on his property, namely to knock before entering a room and not to roam around the property unsupervised. These rules applied to anyone, everyone, and were actually initiated by his wife when she.
But y'all see how they try to make it seem like the rules just only pertain to females that Mr. Kelly was dealing with. These rules were put in play for anything walking. Man, woman, child, dog, cat, horse, whatever. These were the rules of the house. No one can roam around this house without asking for permission or being escorted by security. Nobody.
Lived on the property. Copeland acknowledged that defendant's girlfriends also followed defendant's rules to wear baggy clothing and not to interact with other men in public. Defendant had girlfriends who stayed at his properties, sometimes for extended periods of time. Some girlfriends lived in defendant's home while others did not. They were free to leave if they wanted to. Copeland never attempted to stop any of defendant's girlfriends from leaving his property. Defendant never asked Copeland to recruit women for him, nor did she ever hear him ask any other employee to recruit women for him. Copeland never saw defendant attempt to prevent any woman from leaving his home. She never saw defendant lock any of his girlfriends in a room, and he never asked for her to confine any of his girlfriends. Defendant's girlfriends had constant access to food and assistance to help them with anything they wanted. 6, Nicholas Williams. I don't remember Nicholas. Williams worked for, and he was an intern and runner in 2003. Nicholas Williams worked for the defendant for a year in 2003 when he was 19 years old. He described the environment as hostile work environment and was disappointed that was not able to use, okay, I think she meant that he was not able to use the audio equipment. I think I do kind of remember him. Is he one of the people that sued for the back wages or something, or was that the Navarro guy? Anyway, different types of people visited defendant at the studio, ranging from professional artists, musicians, actors with whom he was doing projects, personal trainer, some of his entourage, and female guests. Williams noticed that defendant's female guests at the studio were young. Williams was instructed not to interact with the female guests. 7. Cheryl Mike, executive assistant from 2014 to 2015. And for those of you who don't know, Cheryl Mike is the mother of London on the Tracks, who is a music producer. So Mike, M-A-C-K, I know y'all get mad. Y'all say I be saying Mike, like M-I-K-E, but it's my southern drawl, okay? So anyway, she met defendant in 2005 when she was working as a talent manager in the industry. She reconnected with defendant in 2013 through another record executive and began working as defendant's executive assistant in 2014. She managed defendant's calendar and worked on projects with him. She also arranged travel for his guests and entourage. Cheryl would arrange travel as requested by the defendant and use the company credit card to book necessary reservations. She used a company known as Preferred Travel to make most reservations. She was prohibited from socializing with defendant's guests. Cheryl received a text message from Azriel in April 2015 asking her to book travel arrangements to California for Azriel, which she did. She later met Jane or Azriel in the lobby of the Mandalay Bay Hotel in Las Vegas, where she was checking into her hotel room. She also saw Azriel in Kelly's dressing room at a venue in Connecticut where he was performing. She was there with several other individuals, but eventually she left when Kelly began massaging Azriel's leg because it made her feel uncomfortable. She said she quit the following day. You're right, girl. Okay, so that is it as far as
That was the end of that. That was the end of that clip. So, and that's shout out to A View from Tracy Point. Y'all go over there. She have all the videos broke down. right there, that particular video talked about the enablers and employers that the government was using to say they were the RICO enterprise. She was using those people to be the RICO. Those are the people that the government consists of, the RICO enterprise. How ironic is it that they use Demetrius Smith, but why didn't they use Barry? They didn't use Barry in New York. They didn't use Darren McDavid in New York. They didn't use June Brown. They was the one from. Neither one of the guys in Chicago was a part of the RICO enterprise in New York. Why wasn't McDavid a part of the RICO enterprise in New York? Why wasn't Milton June Brown a part of the RICO enterprise in New York? Huh? They talked about employees of Mr. Kelly, right? Right there. Y'all head over there. Check out those videos from Tracy. Make sure y'all liking the videos. Make sure y'all sharing the videos, leaving comments for engagement, because what she's doing is real great work over there. She's doing great work over there. So make sure y'all get over there and like the videos, share the videos, leave comments for engagements as well. But go over there and re-listen to the videos for yourself as they talk about the enablers, right? Why? These people that they claiming who were saying these girls were young testified that these girls, they checked identifications. They had to be of age. They didn't appear to be young. The age limit to get backstage, they couldn't recall if it was 18 or 21. Rather, 18 is grown, 21 is even growner, but 18 or 21 you had to be to get backstage. Like I said, the title of that video right there was The Enablers and Employees. The Enablers and Employers. That was the title of that video on Tracy Viewpoint. So, man, we heard the government today say some crazy shit. That Diana Copeland took Jano number 5 to the doctor, and the doctor gave Diana her results. That's crazy. I just never heard nothing like that. Then you heard him say, Mr. Kelly, you heard them say Mr. Kelly would have female perform oral sex on him in the car and instruct them to be loud so that the people in the front could hear what was going on. But then you got people like Anthony Navarro saying that they had to turn the radio up, they had to turn the rearview mirror up. Like, it's just so much shit that they said. They brought up Aaliyah. Man, come on, man. What if you all gonna keep bringing up Aaliyah? Can we see the proof? We want to see the annulment. Give us proof of the annulment. Because even if there was a marriage, as y'all contend it was, even if the marriage was annulled, there still has to be a docket number where the court was motioned to move. Give us some type of proof that something took place outside of this motherfucking bullshit marriage certificate you all claim. People like Demetrius Smith, these are scorned individuals, man. People who no longer employed by Mr. Kelly, who was pissed off that Mr. Kelly wouldn't talk to them. Who was pissed off because Mr. Kelly cut off their wealth of finances. People like Cheryl Mack, who was pissed off because she felt as if she deserved more than what she was getting. It seems to me that the government purposely went and tried to get all of the people who have worked for Mr. Kelly, who has an axe to grind against Mr. Kelly only. I'm like, Mr. Kelly now. You mean to tell me ain't nobody have not one good thing to say about me? Not one person? Man, look. I appreciate each and every one of you just for coming over this morning. Thank you all so much. Just continue to pray. I know it was difficult for us to sit through this hearing this morning, but you know, and we gotta stand on our faith. You know, we gotta stand on our faith. We have to stand on our belief. And if we and if our faith is in God and our trust is in God and our belief is in God, then what we witnessed this morning, we can't allow that to adjust how we feel. We can't allow that to control our emotions, because at the end of the day, we're not looking for right now vindication. Right now, we're looking for the overall vindication. You know, we don't want to have no happy moment. We want it to all be over with. We looking for it to all be over with. So if y'all got trust in God, believe in God, y'all faith is in God, don't get discouraged about little things that you see right now. Because guess what, man? This fight is going to continue. This fight is going to continue. And when God feels as though the time is right for this fight to finally end, then this fight will be over. But until then, we just have to keep the faith and keep believing and keep coming out here, keeping this case alive, keep talking about the case, keep talking about the evidence, keep talking about the facts, regardless of how people feel, regardless of what people say. At the end of the day, you have an individual preference to believe what you believe. And if you believe someone was mistreated and done wrong based off the things that you've witnessed and seen, then you have the right to feel the way that you feel. You have the right to raise the question. You have the right to demand answers. Thanks a lot, J-Rock. Thanks a lot for the $10 super chat. I really appreciate it. Really appreciate it, my brother. To everybody in the comments, y'all stay prayed up. Let's keep prayers going. Let's stay strong. Let's stay together. Because united we stand, divided we fall. We can't allow separation to come in and break up the strength of what we could be. You know, we're looking forward to better days to come. You know, we're looking forward to better days to come. And I'll catch you all tonight. Back on live, probably. But if not tonight, then it'll be tomorrow morning. Because I'm about to go get my walk in when I get off of here, because I wasn't sure what time the hearing started. So I stayed back to set up for the hearing. So now I'm about to go get my walk in. And tomorrow morning we'll be live from my walk like I was doing. And we're going to get it in. If you like to donate to me, you can cash out me at Big Viral Opinion on Cash App. If you like to donate to the channel, you can hit the super chat or the super thanks. any information, y'all can reach out to me at my email, bigvilepinion88@gmail.com, or y'all can reach me over on Twitter, X, formerly known as Twitter. I'll be on there. Keep supporting to keep up with the case documents and filings. Head over to Instagram, to Justice for RK on Instagram, and just keep supporting the people that's out here, especially on the YouTube streets, that's putting out the information that's in this fight to bring understanding and clarity and context to the things that have taken place in the case of Robert Sylvester Kelly. And just keep supporting these people, man. It ain't about an individual person. It's about us coming together to push this movement and get it out there to the masses. And we're going to continue to do that. I love each and every one of y'all. From your boy, Big Vibe Opinion, it's been great. I'm about to sign out. Until next time, make sure you like, share, subscribe to the channel. Make sure you like, share, subscribe to the channel if you haven't already. And this is the type of content we're going to come out with and give you every day. We listen to the content and we ask questions. That's it. That's all. Until next time, I appreciate y'all. We out of here.